Hello everyone, this is Ajisha, Assistant Professor, Department of Management Studies, Rohini College of Engineering and Technology. This topic deals with Industrial Disputes Act. On completion, students will be able to explain the scope and applicability of the act, understand the dispute redressal bodies. Industrial Disputes Act is a primary legislation governing dispute resolution in India. It was enacted to provide for the investigation and settlement of industrial disputes, to prevent illegal strikes and lockouts, to provide relief to workmen during layoff or after retrenchment or wrongful dismissal. It also provides for the mechanisms of conciliation, arbitration, and adjudication to promote measures for mutually beneficial relations between employers and employees. To understand the scope of the Industrial Disputes Act 1947, it is important to understand the meaning and import of the terms industrial dispute. This act states that the former describes any dispute or difference between employers and employees, or between employers and workmen, or among workmen, which is connected with the employment or non-employment or the terms of employment, or with the conditions of employment of any person. This act defines the latter as business, trade, undertaking, manufacture, or calling of employees, and includes any calling, service, employment, handicraft, or industrial occupation or avocation of workmen. Therefore, to attract the application of the Act, a dispute would have to occur in an establishment falling under the definition of industry. In other cases, there is no scope for governmental interference, and thus the only recourse is to approach courts or engage in alternate dispute resolution mechanism. Key elements of Industrial Disputes Act. The primary purpose of the Act is to provide machinery for settlement of disputes between employers and employees, ensure the continued production, supply, and distribution of goods, protect the rights and interests of employees, encourage settlement of disputes by conciliation or arbitration, protect workers against discharge and discrimination on the grounds of participation in lawful activities during the pendency of any proceeding, provide for publication of particular material regarding settlement of industrial disputes. Authorities under the Act. Works Committee, joint committee with equal number of employees and employees representatives for discussion of certain problems. Conciliation is an attempt by a third party to help the disputes. Board of Conciliation, 2 or 4 members as government thinks fit appoint as Board of Conciliation. Arbitration, appropriate government can appoint a court of inquiry as an ad hoc body. Adjudication, labor court, industrial tribunal, or national tribunal to hear and decide the dispute. This is the machinery for industrial dispute settlement. There is a preventive machinery and a settlement machinery. Under preventive machinery, there is workers' participation in management, collective bargaining, grievance procedure, tripartite bodies, code of discipline, standing orders. Under settlement machinery, conciliation, court of inquiry, voluntary arbitration, adjudication. Key elements of Industrial Disputes Act. This act provides for both internal and external bodies for dispute resolution and prevention of strikes, lockouts, and mitigates the use of unfair labor practices from a compliance perspective. External mechanisms generally require a great deal of effort, expense, and time. Internal mechanism is preferable because the likelihood of having to rely on adjudication of alternative dispute resolution reduces, thereby providing an amicable working relationship. Hope this video benefits you. Thank you.